Well, item number 7 in the hearing list, well,
Yes.
a problem with our junior colleague. I pray for adjournment next month after 4th month.
2018 matter.
Well, I'm sorry because my assisting colleague, well, they got injured.
Prayer for adjournment in this case.
I'm
The
sorry,
adjournment of hearing of this case has been made in this. A prayer for adjournment of hearing has been made in this case on the ground that the briefing council is. Why is he unable going for a holiday?
No. One is fellow got injured, another is the children's exam.
Due to personal reasons. Full stop. Since the prayer is not opposed and considering the ground on which the prayer is made, notwithstanding the fact that this is an old matter pertaining to year 2018, the prayer stands allowed. Let this matter be listed for hearing again after 4 weeks.
Amen.
Maybe. I have filed a motion case, my lord, new case. Earlier it was filed a withdrawn, non-having of the appointment letter. Now I have got it. So, my lord, it may be taken on, it was filed on 28. So maybe it may tomorrow, my lord.
Friday? Friday?
Well,
May I please? This matter, your lordship, earlier notice was issued on 26th, returnable on 9th. My lord, it is interim of prayer was returnable on 9th. Well, in the meantime, regarding civil engineer case, my lord, in the meantime, government has they have done on 29th at the 11th hour, that is Saturday. They issued an order. A junior person is placed into that post, my lord. Today definitely is going to be assumed the chairs, new incumbent. My humble prayer, this is I am my lord, to bring to the knowledge of the court this subsequent development. Can it be on my lord? Well, it is not possible today. Tomorrow, my lord, at least, my lord. Highly applies, my lord.
May I please? I'd like to mention, my lord, one writ petition is already fixed on 7th of April, my lord. But, my lord, in the meantime, they have, having come to know the fixing of this court, my lord, on 7th, have issued on another impugned communication, which is also put to challenge. When that writ petition is fixed on 3rd of, my lord, April. So I'm praying for listing this earlier writ petition on 3rd of April, my lord.
Which is already fixed on 7th.
Yes, Lord.
Not possible. That you have to file an IA. After 2 years, if an allegation is made that the judge is, nowadays allegations are made, na? The judges manipulate the date fixing and all. Sorry. Yes.
May I please, your lordship, with the consent of the other side, I'd like to mention item number 15 of the daily list, my lord. Madam, here matter may be adjourned for the day, my lord.
Item number?
15, my lord. One second.
You are appearing for whom?
PK Munir, my lord, on behalf of PK Munir.
On the prayer of learned counsel for the applicant, this matter stands adjourned for 2 weeks. List accordingly. Yes.
Much obliged.
May I please, your lordship. Lordship, I beg to mention one writ petition for listing for admission. Matter becomes infructuous, lordship.
When do you want it?
On 9th.
Daily list for withdrawal, item 1.
Yes.
Wait, please, lordship. As far as instruction of the client lordship, I want to do this.
You are Mr.
Amjad Shah.
Mr. Amjad Shah, learned counsel for the petitioner submits that he has instructions from his client to withdraw this lead petition. The prayer for withdrawal is not opposed by the respondent's counsel. Huh?
Liberty may be given.
No, but then you have to tell why you want to withdraw.
But in this case, lordship, some material fact is not mentioned, lordship.
Has the respondents filed affidavit?
No, lordship, this is the.
Then you write,
Sure,
Mr. Amjad Shah, learned counsel of the petitioner submits that there is some defect in constituting the petition. Therefore, he has instructions to withdraw the same with liberty to file afresh. The prayer is not opposed by the respondent's counsel. As such, his writ petition stands disposed of on withdrawal with liberty as paid for.
May I please, lordship? I
Yes.
have to withdraw this writ petition with liberty, my lord, because some technical defects are there. We shall file a fresh, my lord.
Same order, just write his name, Mr. B. Purkastam.
Supplementary list for motion, item 12.
13 years they are working as the DMO member. And as per the 2015 notification, there is a judgment from your lordship. But on the basis of this 2015 notification, they are entitled to be regularized. So accordingly, my lord, proposal for regularization was sent at page 58, man.
So according to you, the proposal for regularization has been sent, but it has not been considered.
Not, they are sitting over the matter, and also, my lord, there is a, for extension of their service. Because after May 24, my lord, they are not getting their salaries. Extensions are done normally, my lord, after 6, 7, 8 months. So there is an extension, representation from the officials, that is at page 66, requesting to extend their services. And there is a also proposal by the DPC for regularization of their service. I'm just showing one paragraph from your lordship judgment at paragraph 12, my lord. On the basis of the 2015 notification, if their services for more than 9 to 22 years, they are entitled to be
So
regularized.
the scheme is still continuing.
Still is continuing, but a general circular has come now. That is what we have impugned here. That is at page 69. The 2015 notification I'm providing you. Now this, because of this impugned order, they will face difficulties. And the authorities are sitting over the matter. That is the 2015 notification. The selection was held, my lord. The select list was set aside by this court.
All right, so we'll issue notice at this stage.
Yes, my
Notice.
lord. Notice, but at the same time, my lord, salaries, they have not got it, my lord, since May 24. So,
On notice on interim prayer also.
yes,
Since May 2024.
yes.
Take down heard Mr. B.D. Das, Learned Senior Counsel, listed by Mr. D. Kolita, Learned Counsel, hearing for the writ petitioners. Anybody from the health department?
My lord, only that impugned notice, my lord, which is general in nature, this should not be applicable to the petitioners.
Is
That
it under
at page
challenge
16.
here?
Yes, page 69.
So all this, see, this notice is of 2015. Without giving them a
No,
chance.
that is all that. I'm just showing that this page 69 notification, it's a general nature. It has come into operation from 18/3/25. Prior to, so this should not affect the petitioner.
Yes, Mr. Bora, are you aware? of
Yes,
the-
my lord. My lord, just now I have a talk with the concerned official, my lord. Let me give some time, my lord. I will obtain the instruction, my lord.
Will issue notice then? Or you want it to be in motion?
In the motion, your lordship may keep it in the next week. I will obtain the preliminary instruction, my lord.
Salary part, I am more concerned because they are
My
not.
lord, after
getting
that,
salary.
it may be considered, my lord.
Right, and you take down so and so for the petitioners. The petitioners are aggrieved primarily due to non-consideration of their request for regularization in service, as well as non-payment of salaries since the month of May 2024. Mr. D.P. Bora, Learned Standing Counsel for the Health and Family Welfare Department, Assam, praised for posting this case again on 9th of April 2000. Is it fine? 9th of April?
Yes, my lord.
9th of April 2025, so as to enable him to obtain preliminary instruction responding to the request and responding to the prayer made in the writ petition. 2 extra copies of the writ petition be furnished to Mr. Bora. Let the matter be listed again on 9th.
Right.
My lord, can it be on 10, my lord? Just one more day, 10.
10? All right. 10.
Because, obliged, my lord.
Item 13.
Yes, who is appearing in this case? Yes, you are appearing.
Yes, Your Lordship.
You are appearing in this case.
Yes, Your Lordship. I think supplement.
13.
From 7. Yes, Your Lordship.
Yes.
Lordship, this is an application against the transfer of the petitioner from the regional office of Guwahati to regional office Tiruvananthapuram. Your Lordship, the petitioner is a deputy manager of National Housing Bank. Your Lordship, the petitioner first joined his service,
Where is the transfer order? Which page?
page number 12. Page number 12, serial number 43. The name is Shri Shubham Kumar Singh.
It's a series transfer.
Yes, Your Lordship.
Okay, what is wrong with this transfer?
Your Lordship, in page number 21, there is the transfer policy of the National Housing Bank. Your Lordship, in paragraph number 4.1, it is clearly mentioned that, may I read that paragraph? An officer shall be considered for transfer to other station or place after 5 years of continuous service at the same station.
Hmm.
The bank shall prepare scale-wise list of officers who shall fall into zone of transfer to other station place in order of maximum tenure spent at the same location at one stretch. The transfer shall be effected based on first in, first out FIFO basis. Your Lordship, the petitioner joined his service on 21st June 2022 at Delhi head office. After that, he served there only for 1 year and 1 month and 12 days.
Hmm.
After that, he was transferred to Guwahati, dated August 1, 2023. And Your Lordship, in Guwahati, he has served till March 13, 2013. On March 13, 2025, the next transfer order has come out. Your Lordship, he has served here for almost 1.5 years. Lordship, but the rule was transfer should be made after the completion of
That's
5
right,
years.
but they cannot make transfer of 43 officials, everybody having 5 years. Some adjustments will have to be made.
Yes,
is it
Lordship, this is true, but in case of the petitioner, only the transfer is too quick. And Your Lordship, the petitioner has only his mother here, who is a 65-year-old lady, and he has to take his mother with him everywhere he joins.
Mother is 65 years old.
65 years.
65 is not very old.
Not a big, and she is ill. Your Lordship, he has to settle. I mean, he just settled here in Guwahati. He adjusted with the weather and the circumstances of this area, but he suddenly again transferred. It's very difficult for him to get transferred in such a frequent time
Mhm.
frame. Your
Yeah, but
Lordship.
sometimes it will happen.
Sometimes it will happen, but Your
Mm.
Lordship, in his case, it is the second time, Your Lordship. So kindly be considered.
You tell your client to go to Thiruvananthapuram. It's a good place. These are not grounds for the court to interfere with the transfer order. Is there anybody else along with you in this case?
Uh,
Any other senior? You have a
No,
senior?
Your
You are
Lordship.
doing it yourself. All right, so you examine the matter and
Yes,
transfer matters are for the authorities to decide. There are some set norms where the court can interfere. Whatever you are submitting, it doesn't come within that. Right? So difficult.
Right.
You want one more chance to make up your mind that the court will give you.
Your Lordship, is there no any chance?
All right, next Monday on the pair. Your name, please.
SJ Hayat.
Jed.
Hayat.
Another thing, my respondent, one Union of India represented by Director of General Human Resources. Union of represent only Secretary, the Minister.
That's correct.
Yes.
These are technicalities. On next Monday for motion. Mr. S.K. Medil and CBC is present on behalf of the union.
Next.
Item 14.
May I please, Your Lordship?
Hmm.
See, the petitioner herein is working as assistant commandant in BSF Lordship. And Lordship, he is aggrieved by the action of the authorities in processing his case for demotion for not completing the Lordship, the probation period, without the in violation of the provisions of the rules and BSF rules. Lordship. So Lordship, I may Lordship to the impugned show cause notice. Lordship,
Yes.
at least 31.
So you are coming against the show cause notice.
Show cause notice is there, but Lordship, the show cause notice itself is issued against the provisions of raw BSF. That's why. Lordship.
Yes. Page number.
Page number 31, Lordship. Prior to that, Lordship, I would like to point out the promotion order.
Hmm.
That is at page number 25. That will make the case clear, Lordship.
Page number 25.
25, it will make the case clear.
Hmm.
May I read, Lordship?
Hmm.
Promotion from Inspector Electric to the rank of Assistant Commandant Electric in BSF. In continuance to Headquarter DG BSF Personnel Signal Number so and so dated 25/11/2016.
Hmm.
I am directed to convey sanction of the President to the appointment of following inspectors electrical on promotion to the rank of Assistant Commandant Electrical in Border Security Force on officiating basis. It is officiating basis with effect from 25/11/2016.
And
Yes.
my name is at serial number 1, Kishan Pal Singh, Lordship.
Hmm.
Then below, Lordship, clause 2. Consequent upon their notional promotion to the rank of Assistant Commandant Electrical, they will draw their pay in the pay scale of pay band 3 so and so with
Hmm.
grade band so and so as applicable for the post.
Hmm.
Then 3.
Now,
Lordship.
what are you challenging?
Now
What-
challenging is, Lordship, page 31.
Yes.
This is the show cause notice issued in August 24, 6 August 24. But may I read the show cause notice,
Hmm.
Lordship?
Okay.
So, Lordship, now under clause 10,
Hmm.
clause 9, Lordship.
Yes.
Clause 9, it says, whereas the DGBSF having carefully considered the facts is tentatively of the opinion that you as a probationer have not made satisfactory progress to upgrade your medical category to so and shape 1 and have been placed under low medical category since 2017 and has this DGBSF has approved for service so having so cause notice as to why you may not, this is may word is there, you may not be reverted to the rank of inspector electrical during the period of probation under rule 10(3) of BSF rule 1969. Now, Lordship, I would like to draw attention to the rule 10(3) of BSF.
Rule 10.
10, rule 10. It speaks about probation. Page 45. Page 45, Lordship. Below,
Yes.
Lordship. Rule 10. May I read, Lordship?
Yes, please.
Probation.
Hmm.
10(1) says about, Lordship, an
Yes.
officer, subordinate officer, or under officer on first appointment. This is regarding initial appointment. Lordship.
Hmm.
On first appointment to the post shall be on probation for a period of 2 years. Specific 2 years is mentioned here. And the central government, in the case of officers, and the authority prescribed in Rule 11, in the case of subordinate officers and under officers, may, for reasons to be recorded in writing, extend the period of probation for such further period or period not exceeding 1 year. So, Lordship, here maximum period is
All right. So we'll allow them to go ahead with the proceeding, but not to pass any consequential order till the next day. You cooperate with the proceedings. The
Lordship.
proceedings will not be stayed.
Yes,
All right.
Lordship.
Yes, heard,
Lordship,
Mr.
Lordship,
Yes.
similar order has been passed by the division bench of the Honorable Delhi High Court also. But they have allowed Lordship. This is the next identical case, Assistant Commandant Lordship. They should not be given effect to Lordship, it is given.
That's what I said.
Yes, same order. This is
All right. I had Mr. A.R. Tevinder, Learned Counsel for the writ petitioner, peruse the statements made in the writ petition. The petitioner is aggrieved by the show cause notice dated 6/8/2024, initiating action against him for reverting the petitioner to the rank of Inspector Electrical from the present position of Assistant Commandant
electrical, BSF.
bracket electrical,
BSF.
electrical in the BSF. Mr. Tahvildar submits that the action initiated by the impugned show cause notice dated 6/8/2024 is wholly contrary to the mandate of Rule 10 of the BSF rules,
1968.
Border Security Force Rules 1969. 69, is it?
69,
68.
69.
69.
69.
So, none has appeared for the respondents, although the name of the DSGI is, yes? Do you have any instruction? No.
No, my lord.
Acha, Mr. So-and-so Gupta, Sage Gupta, learned CGC appears for the respondents and prays for some time to obtain instruction. Issue notice of motion returnable on 15/5/2025. Since Mr. Gupta has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. extra copies of the writ petition, requisite in numbers be furnished to the learned CGC within 3 days from today, heard on the prayer of interim relief, having regard to the facts and circumstances of the case. The respondents are granted liberty to proceed with the show cause notice dated 6/8/2024. However, no effective order adversely affecting the rights and interests of the petitioner shall be passed without obtaining the leave of the court.
Daily list for admission item 3 and 4.
You give it to me.
Lord, before my learned friend starts, my lord. My lord, I am respondent number 5, the director, my lord. Now, initially, when the writ petition was filed, the order was passed by our client. Subsequently, same order has been reiterated by the in charge was appointed. Now, my lord, fact of the matter is, even today, I am getting the salary of director. I'm still holding the office. What I have done, my lord, in fact, we have challenged my order where I was sought to be superannuated on attaining the age of 65 years. Well, that matter is fixed on 7. In fact, that matter was heard at length. It was reserved for order. Subsequently, my lord, some confusion was there. Now the matter has again been fixed on 7. So may I pray, my lord, this matter may be taken up on any date after 7th, because it has got a bearing. If I succeed in that case, then, my lord, this item number 5114 will be, my lord, have to be tested along with the other case. 7th, it is fixed.
In my respectful submission, that case has to be fought in its own merit, and this has to be decided on its own merit. Fact remains that on the date when the order was passed, he was not in office. He obtained some order from this honorable court. That also,
Mr. Mohta, just 1 minute. If you say that you are not going to question his authority, jurisdiction to pass the order while arguing in this matter, then I will hear this. But if you make any arguments pertaining to that, then it has to go either along with the other matter or immediately after that matter is decided. So you have either of the two options.
before Lordship fix the mind, kindly listen to me.
Okay.
Here what happened? I was superannuated by applying 56J. He matured. But meanwhile, he attained 65 and central government said, you retire on such and such date, you will go on retirement, completing your age of superannuation. This, he approached this honorable court. This honorable court said, well, we are staying it subject to that you will not be, this stay will not be applicable in respect of the post of director. He claims that he is in the rank of professor.
You have that order passed in the other matter.
Yes, yes. It is annexed. Annexed. It is annexed.
Annex to which writ petition?
1 second.
Who contributes annexed, sir?
Yes, 207, my lord, of our affidavit.
In my petition also. it
Page
should be here.
207.
Our petition.
Item 5114 of 24.
5114, yeah.
Page 207. And the operative portion is at page 210. Para 7, 8, and 9.
last two paragraph, 7 and 8, no, yes.
So he is continuing in service according to you by virtue of this interim order.
Yes.
All right, now.
And there's one more aspect, my lord. On my lord, 17/9/24, he was prematurely retired by invoking 56A. There was an order on 19/9/24 after this order where an in-charge director was appointed in my case. So on 17/9/94, when the impugned order and the challenge was passed, I was very much the director. Even today, I'm director, my lord. They're paying me salary of director. Because they cannot remove me, my lord. That's the scheme.
So you removed him under 56J and
Yes.
somebody else removed you under 56J.
Yes.
So your removal is stayed. But
No, it's not that, my lord. What I'm saying is, I was sought to be superannuated on attaining the age of 65 years.
Right.
Because the stand taken by the ministry is, my lord, that as per the bylaws of the society, one would retire at the age of 65 years. I say, both as a professor, that is a faculty member, and both as a director, as per the central government circular, I will retire at the age of 70 years. That matter is fixed on 7. There is a stay order. Now, my lordship has seen at page 210, though the honorable court intended something, but meaning that is coming out is something else. It's not confined to director, that means confined to both. I'm not taking advantage of that. Kindly see.
what is the meaning of para 8?
But if I am to give a meaning to it, not only director, as a professor also it is state.
That would be
No.
beyond my comprehension. That would be beyond my comprehension.
No, this is not a question of
Loud and clear.
Anyway,
Words are loud and clear,
no, this is not loud and clear.
very open.
Anyway, so therefore my submission is, my lord, if today this matter is taken up and is closed on the plea that I was not competent to remove him, then my lord, it will have an effect on my other petition which is fixed on 7. So therefore I'm saying, all that I'm saying is, this matters today is, my lord, first. 7th matter is fixed. Any date after 7, this matter should be heard. Only at least on that day, I'll know where I stand in that case. If, my lord,
7th it is fixed for what?
disposal, already, my lord, matter was heard at length, it is again fixed for hearing.
That case was, well, being
I
heard.
think my prayer is quite reasonable. I am not saying, otherwise, my lord, it will have an effect on the other case.
Well,
Mr. Mohanto, you see, the hearing will again, today also you can argue, but then either we'll have to call that matter, but this is a part-heard matter.
Part-heard matter. Otherwise, it could have been tagged with that.
What happens is it becomes difficult to write a judgment in these circumstances. One line here and there might affect either of you.
Yes, yes.
I hope you will understand as very senior counsel. Otherwise, there is no difficulty. I want to get rid of this matter.
No, my lord, even I am prepared to argue this case. It's not that I am not prepared to argue, but the only thing is, my lord, since the other matter is pending on fixed, and a matter which was filed earlier in point of time, that matter, in any case.
I would have called that record and heard
Yes,
it
but
after
for
tomorrow,
that,
it is
it's a part-heard. Yes, yes.
So that is the question I asked on the previous.
In fact, lordship would recollect, the other matter was listed before lordships. Then the government advocate said, no, this is part-heard before. Then lordship sought a clarification from the
So
registry.
anyway, you guide the court what is to be done.
Yes.
These are matters where I don't think there should be
Any controversy.
unnecessarily contest.
Yes, yes.
true, my lord,
Because once the court is informed that there is a matter pending, judgment will not come here unless that is out. So therefore, after today, there will be again hearing. And that hearing could be again a fresh hearing. So what do you want to do? You decide.
no point fixing
That's what-
other hearing again after today's hearing.
That's what I'm saying.
No point.
Because without
No,
knowing
my
the
lord,
outcome of that
my-
case,
my-
just a minute, without knowing the outcome of that case,
Yes.
it will be very difficult for the court to write a judgment in this matter.
True, my lord, I appreciate it, that if a finding is arrived at by the other court against him, then it would be a cleansing for this.
Correct,
case.
correct.
That is there. That is there. But otherwise also, my question was that even if he sustains in his post, then also this order is bad. This is one point. that is one point.
That is an argument you can make if he
Yes.
is sustained.
Then also,
But today we don't know which way it will go.
Therefore,
I cannot write two judgments and going
my
into
my difficulty is.
one
yeah,
going towards Nagaon, another towards Tezpur. I
Other
can't write.
other case is being dragged for last probably 3-4 months. Hearing.
So that we understand.
That is
I wanted to write the judgment here only today.
Exactly, my lord, exactly. That is how.
But it
this
will
works.
be, you cannot argue about his, then I can consider. You cannot make any argument and I'll
No,
not refer
well,
to
I
it.
will have to argue not
That's the-
personally against him, but officially.
That's the problem. How do the court deal with it? How does the court deal with it?
Now, my lord,
If
lordship
we
will have to-
recognize his presence here, it will have an effect on the other proceeding.
True.
If we do not recognize,
My lord, I can only indicate one thing, my lord. There is a particular clause by law number 20 that was not applied in case of my client. Only reason is the peculiarity of the case, because I was appointed to a non-tenure post. At the executive committee meeting of the board of directors.
all right, what I can do is,
10th,
what
let
I
the
can
matter
do
be
is-
fixed on 10th.
if you want, these are the two options. And here we'll give the priority to Mr. Mohanta because his client is the one who is suffering.
Yes, yes.
Either I can release it from Parter and have it tagged with the other matter on 7, so that one judge deals with the whole thing. Or postpone the matter awaiting the outcome of the other writ petition. Which of the two, if you want to
Quickly,
think
then,
about it, you
lordship
take
may
some
fix
time
it
and
at-
think.
Yes.
Lordship may fix a date here
Hmm.
after 7th. On 10th, my learned friend
Yes,
is saying.
yes, yes.
On 10th.
Yes, 10th.
But I think this matter should have been heard together. Why this separate? These have a bearing.
It has.
If he doesn't
My lord,
get a clean sheet from the court, it will
Then
have a
this
direct
matter can be
bearing.
tagged with that matter on
my
7th.
lord, that would again further delay that matter. My apprehension is this. If that order can independently, that case can independently be decided, and then it will have a bearing here.
Mr. Mahanta, it is not for the judge to say all this thing, but in that matter, it is that unless these matters are decided, you cannot pass an order here. You are in a,
Quandary. My lord, no. If that case, as I had said, my lord.
and I cannot pull that matter. All I
Yes.
can do is release this, but I
Not
cannot
necessarily,
pull
not
that out.
necessarily, my lord, this releasing will, again, it will take some time. Lordship has heard it sufficiently. Let's
Alright,
be on 10th.
what
Let us see
is-
what happens.
10th.
You want it on 10th?
10th, মহাবিজয়ন্তী। বেলা তো 15 আছে নাকি?
ও আচ্ছা, তেনেহলে আর বন্ধ বিহু পিছল যাব 22 তারিখ বা 24 তারিখ 24 তারিখে লগ দাদা
হ্যাঁ, বিহু।
অ 22 তারিখে বহুত ম্যাটার ফিক্স হয়ে গেল 24 লগ
Take on heard Mr. K.K. Mohanty, and senior counsel listed by me, counsel appearing for the commissioner.
5 তারিখে নহয়
Also heard Mr. K. Chaudhary, and senior counsel listed by Ms. R. Kapati, appearing for the private respondent in both these cases, Mr. A.K. Datta, Leonard CGC. And who is the other? Today you are for the both. Then the another CGC. And Mr. K. Gogoi, Leonard CGC are present on behalf of the respective official respondents. The attention of this court has been invited to another pending proceeding in the form of WPC number 3769/2024, wherein the private respondent has questioned the order retiring him on service on attaining the age of 65. Full stop. It appears that on 30/7/2024, an interim order was passed in that case, suspending the order of superannuation of the private respondent, as a result of which he is still continuing in service. Referring to the issues involved in this writ petition, Mr. Chaudhary submits that since the other writ petition in number 2 DDBO is at the advanced stage of hearing and is fixed on 7/4/2025 before this court, these matters be taken up any day thereafter, since the outcome of WPC number so-and-so will have a direct bearing in the present writ petition. The said contention, although Mr. Mohanta has not denied and disputed the said contention, yet he has expressed urgency by stating that his client has been unduly made to retire by erroneous invocation of FR 56J. Full stop. After hearing the submission of learned counsel for both the sides and as agreed to by them, these matters are fixed again on, when do you want it?
24.
24 2025 as fixed item for further hearing.
The affidavit that was filed by us, if one additional affidavit, that may be tag office may be there.
Office to take the additional affidavit dated 27/3/2025, filed by the writ petitioner with the record of this case.
Okay. Deep.
Item 5.
Item 5, Lordship.
Yes.
As per the last order, Lordship, I filed my affidavit, one affidavit, although it is not take with them on a record. Lordship. It is filed on 27th, Lordship.
Have you received the copy?
Yes.
You want to file any reply?
Well, only the factual things, whatever I have been stated in the writ petition, they have reiterated.
What is the matter about?
My lord, a prolonged suspension, my lord. 14 months, still continuing. Review done within time, departmental proceeding, search it, file within time. Enquiry reported, my suspension was on 27/1/2024. Enquiry reported submitted on 29/10/2024. Still petitioner is under suspension. And your lordship knows, as per clause 2.1.4 of the departmental manual, the reasons for suspensions are given. There are signs of tampering with the evidence.
So where is the affidavit?
That is not take with them on a record. I have already been filed, Lordship.
They could have called it.
We'll take it up tomorrow. Let it be tagged. Mr. J. Patori, learned counsel is present for the petition. Mr. J. Henning, learned standing counsel, Revenue Department, Assam submits that the affidavit filed by the department on 27/3/2025 as per the direction of this court is not available on record. First up, considering the relevance of the affidavit, this court is of the opinion that the affidavit is required to be perused by the court as such, and in view of the urgency expressed in the matter, day after tomorrow. Let this
nothing,
matter be
nothing.
listed again day after tomorrow as a fixed item by tagging the affidavit with the record of the court. What is it? Sure.
Lordship,
Day after tomorrow,
Lordship. Tomorrow I
As
have
the-
some other matters fixed.
as a fixed matter in the top of the list of admission items.
Deeply.
Public.
Item 6.
Can I have a look the last order, my lord?
Lords,
It was
it's-
been given, my lord.
Lordship, here in this case, Lordship, I talk with the authority, Lordship. They will send the instruction, Lordship.
Place my area salary, my lord.
Lordship, they will send the instruction.
And this is of 25th March.
Yes, Lordship, Lordship, but due to some holidays, Lordship, last holidays, they are preparing, Lordship, they will send.
No, but what about the amount?
Lordship,
Place my
that's
area
that's why,
salary.
Lordship, can you fix the matter tomorrow itself, Lordship? I will.
Day after tomorrow.
Lordship.
So and so, you give right, on the request from Mr. J.K. Goswami, additional senior government advocate Assam, let this matter be fixed again day after tomorrow, that is give the data as a fixed item.
For hearing, item 8.
So you have participated in the selection process.
No one.
No,
Because
that's
my
what-
lord, our application was not accepted. In the advertisement, my lord, our main grievance is
Where
this,
is where is the advertisement?
my lord.
Page 50.
30, my lord.
No, where is the advertisement, please? Which page? All right, now where is the, you did not participate in the selection process.
My lord, what my learned friend referred to.
They have written in the petition that they have participated. But he is saying they have not participated.
No, no.
You mentioned that you have
There
participated.
may be some puzzle, my lord, as per my petition, my lord.
Which is your item?
Sorry, my lord, my item is 9. My lord.
Very confused.
Sorry, my lord.
You are a little before time.
Earlier two occasions, they all not appeared.
All right, in eight you give it. Yeah. None appears for the writ petitioner on call. Mr. J. Henry, learned standing counsel for the Revenue Department, Assam, and Mr. S. Porthakur, learned counsel for the private respondents, are present. First up, record reveals that the petitioner's counsel was absent on as many as 2 previous occasions when the matter was put up before this court. First up, going by the nature of relief prayed for. No, then you write, considering the fact that the subject matter of the writ petition is validity of a select list published on 2/7/2018, whereby the private respondents were selected for appointment as Gauvuras, and considering the nature of relief prayed for in this writ petition, it is apparent that the matter has become infructuous by lapse of time. In view of the above, this writ petition stands closed as infructuous. Yes.
My lord, may I submit?
Yes.
But the background of the case is this. Actually, Government of India, there is a department, Ayur. Ayur includes Ayurvedic, Yoga, and homeopathy, etc. That 5 disciplines. 5 disciplines. These are
1 minute. Yes.
These are Ayurvedic, homeopathy, but not except allopathy. Ayurvedic, homeopathy, naturopathy, Unani. 4 disciplines. And 4 disciplines together taken into together and it is called IUR. So there is a ministry.
No, we'll come to that. What is your case really?
My case is this, my lord. That is why, my lord, I am saying the back.
No, you first have to tell the case.
My lord, to tell my case, that is to be said before your lordship. Otherwise, it will be difficult because.
Oh, are you aggrieved with an advertisement or appointment of someone? That is the case here.
No, my lord. We are not agreed with the advertisement because that we were excluded from this. Out of 4 branches, my lord, they are treated equally by the ministry of this IUR. And advertisement always made, my lord.
So you want the advertisement of 11/1/2019 to be set aside?
11/1/19.
What happened to this advertisement? Where is the 11/1/2019 advertisement? Page number?
Page 30.
21.
Page 30.
Oh, somebody is saying 30th, somebody.
Annexer 5.
Yes. So this is for engagement of Ayush doctors.
IUR doctor.
So has the engagements been done?
Yes,
Already done?
Yes.
that is in their reply affidavit in reply.
It is done.
The doctors have already been engaged.
Appointed.
All are already been engaged and they were made party in their writ petition.
So how this advertisement can be set aside now?
No, my lord, advertisement can be set aside because this, if the selection is illegal, selection will go, that advertisement will go out.
Why the selection is illegal?
Selection is illegal because, my lord, we were ousted from the advertisement. Because we are in the equal footing. We are in the equal footing, but in every time, my lord, the homeopathy discipline is kept aside.
That is not a ground to set aside there. You may have a grievance.
My lord, I have grievance.
I am telling you, please listen.
My lord.
You may have a grievance that nobody is denying.
Yes.
But that doesn't mean the other appointments should be interfered with. Your case is that you should also be allowed to participate in that. That is your case.
My lord, regarding participation, my lord, advertisement already executed.
Correct.
Selection
So
is
you understand,
without
you
interfering
can
with
waste
this.
some time, but
My lord, your lordship would be pleased to turn to page 9, para 6. That is my case, my lord.
page 9, para 6.
My lord.
One minute. Yes, please.
May I read, my lord? That the director Ayush Assam issued a letter dated 3/5/2018 to the joint
No,
secretary.
you are reading para 9 of your writ petition.
Page 9, page 6.
Para 6, page 5.
Page 9.
Yes, please.
Okay, fine.
Yes.
Yes. Para 6. That the director Ayush Assam issued a letter dated 3/5/2018 to the joint secretary to the Government of Assam, Health and Family Welfare Department, wherein showed the numbers of registered doctors in homeopathic stream as 1301, out of which 325 is appointed, and there remains 976 as on date of the letter, and subsequently there is increase in registered doctors HMO. On the other hand, the said letter reveals that there was 1012 registered Ayurvedic doctors, from which 903 appointed. So there is unemployed doctors numbering 110 as on letter dated 5/3/5/2008. From 3 homeopathic colleges, 75 homeo doctors come out yearly. On the other hand, from 1 Ayurvedic college of the state, namely Government Ayurvedic Medical College and Hospital, Jalukbari, only 40 doctors come out per year. So the unemployed homeo doctors are increasing annually. But the authority is giving more opportunity to employment to Ayurvedic doctor, neglecting the employment of homeopathic doctor, which is against the policy formulated by the central government from time to time. The said letter also clearly stated that there is shortfall of 300 medical officer hemio. The said letter also requested to create at least 300 posts of medical officers homeo on regular basis under state health department at the earliest to meet up shortfall of Ayush medical officer. The letter also stipulated that there are 15 numbers of vacant posts of medical officer homeo due to retirement, and the letter recommended for filling up those posts by direct recruitment through medical health recruitment board Assam. And it is also stated that eligibility for the post of medical officer homeo is BS MS degree as recognized by CCA Central Council of Homeopathy, New Delhi. Photocopy of letter dated 3/5/2018 is annexed here with at annexer 4. My lord, annexer 4, your lordship will get the said letter. Yes, my lord, your lordship will turn to page 28. That requirement of homeo doctor.
So, Mr. Chair,
your lordship.
just a minute, you please have a look at the prayer
My
in
lord.
your read petition.
Yes.
Your case is that your clients who are homeopathic doctors
Yes.
were not given adequate opportunity to be recruited as doctors, although they are equally qualified and equally competent. Therefore, this advertisement notice, which did not include homeopathic doctors, is bad. Now, although the private respondents 4 to 26 have already been appointed pursuant to selection process, you want their appointment to be set aside. Do you think this order can be passed by the court? Now, you listen to this. Number one, if not, the court is saying that your clients may have a genuine grievance, that they are not being given adequate representation in the government hospitals. But that is a different cause of action. That has nothing to do with the appointment of others. Therefore, perhaps the best way for you would be to file a writ petition seeking a mandamus upon the government to consider your clients for recruitment by giving the correct updated facts and figures. If you do that, then the court can consider it objectively. Otherwise, this petition will be dismissed whether you argue for 10 minutes or 20 minutes or 2 hours.
Here,
You know that.
Lordship, here, your lordship, earlier occasion, I came before your lordship, challenging this advertisement. So, my prayer that I may be granted interim relief, my application may be accepted. But the learned single judge did not. So accordingly, I filed the writ appeal, my lord. When I filed the writ appeal, in the writ appeal, Honorable Division Bench held that, you see, advertisement is already over. Now we cannot help you, but you can go for fresh writ petition. And when this writ petition will be considered, in that case, that appointment of the persons in pursuance of the advertisement may be considered whether it will be subject to the result.
That's
of
right.
this
So
petition.
that is the same thing almost. I'm not aware of the writ appeal. What will happen is if I write a judgment here, it may affect your client's chances. If you withdraw it and keep it open, it will be perhaps much more helpful for your
In
client.
that case, my lord, your lordship would be pleased to call for the writ appeal court.
Nothing. I will either pass a judgment today. If you want to withdraw, that chance I can give you with liberty. That is, as a lawyer, you are to take a call. Correct?
My case is this, my lord. Every time they are
All right,
advertising.
all right. You conclude your argument.
Every time they are advertising the post, my lord. But homeopathy doctors are sidetracked.
Then why don't you file a petition with that prayer? If they are sidelining you, that doesn't mean somebody else's appointment should be set aside. This is a basic matter of basic
No, no,
common sense.
every time when we come for challenging the advertisement, challenging the advertisement, every time they will advertise. I will file the writ petition and immediately what they did, that already applications are accepted.
That
So
I can't say.
our grievance is
I
not
can't give you
considered.
legal advice on how to
Mala.
file petition.
Mala.
That I can't say.
Mala.
That is for you or your clients to figure out. What petition is to be filed, what prayer is to be made, that we can't give you that advice. All I am saying is, there is nothing live in your writ petition. Therefore, I can either pass a reasoned order, but if it goes against you, which in all probability,
Your lordship may pass.
then it will create problem for your clients in future.
Maybe, ma'am. Your lordship may pass. Your lordship may pass on merit of this case.
Okay.
Yes,
Can you argue?
yes, ma'am. My argument is this, my lord, your lordship would be pleased to, I'm looking into the annexures, my lord.
Yes. Which annexure you are referring to?
My lord. First, I refer to annexure 4, my lord, to your lordship. The vacancy position.
Annexure 4.
Annexure 4, my lord, vacancy position and requirement, my lord. Your lordship will see in the box stream, number of registered doctors, regular post of medical officer, SMO under health aid department. So your lordship, homeopathy 1310, Ayurvedic 1013, and regular post under health 75. There is Ayurvedic is 392. So my lord, contractual post of medical officer Hemu including RBSK 250, they are 511. The total, my lord, we are 325. They are 903. They are 903, my lord.
Acha, Mr. Sheikh, your clients had filed an IA in this writ petition,
My lord.
seeking to participate in the selection process.
My lord.
What is the number of the IA?
My lord, that number. One six. Not that. That I am not getting. That was dismissed, madam.
Is there any other disposed of IA in this writ petition?
I was.
1655 is for amendment of writ petition.
This is amendment of writ petition. But I remember there was a petition, madam. That was rejected.
You have a look at this.
Madam.
This is the IA which is available in record. This is for amendment of the writ petition.
My lord. This is with me, my lord. Amendment.
But you are saying there is an IA seeking leave to participate in the.
No, my lord, that was in the earlier writ petition, my lord. In earlier writ petition, I filed the writ petition, my lord. And here what happened, my lord, there was a prayer that I may be allowed to participate in.
Where is that order in the earlier writ petition?
That is not available with me, my lord.
All right.
That was not allowed by the learned single judge. When it was not allowed, against that, my lord, we filed the writ petition, writ appeal.
All right.
Writ appeal.
Yes. Anything else?
My lord. So this was the advertisement, man. Breakup. And last paragraph, my lord. Considering the popularity of homeopathy as an alternative non-allopathic system of treatment and to maintain rationalization of Ayurvedic and homeopathy medical officers in the state, the government is requested to create at least 300 number of posts of medical officer hemio on regular basis under state health department at earliest to meet up the shortfall of Ayush medical officer in the state. Now your lordship would be pleased to turn to page 30.
Yes. Page 30.
Yes, my lord. Another advertisement, my lord. It was of, oh, my lord. No, my lord, it is the continuation. Now your lordship will turn to page 31. Office memorandum. It is issued from the Ministry of Health and Family Welfare, RSC Division, New Delhi, ma'am. In continuation of letter dated so and so regarding engagement of Ayush doctors. Well, what I have already pointed out, Ayush included this homeopathy, Ayurvedic, naturopathy, and Unani. Program under NSP, it has now been decided in consultation with the Department of Ayush that the service of Ayush practitioner may be utilized for RM so plus A activities as detailed below. So,
So
my lord,
advertisement is at page 50, page 30, is it?
yes, my lord.
Page 30.
Yes. Now your lordship,
The annexure filed by pagination is some.
now your lordship will turn to page 34.
Yes.
It has been, it is also from New Delhi, my lord. It has been recognized that in order to meet the unmet need of the spacing, there is an urgent need for increasing provider base IUCD services in India. As a result, MOHFW Government of India has taken a policy decision to permit Ayush providers with exception of Yoga and naturopathy to perform IUCU insertions after training as per the circular being developed by Government of India. This curriculum will be shared with your state soon, where after the states may utilize Ayush doctors for insertion of IUCDS at peripheral centers. So
What is
every-
IUCD? What is IUC?
Well,
What is IUCD? What does it mean?
Intervenal, some injection type. Some injection type. So, IUCD,
Contraceptive device.
IUCDS, IUCD.
All right.
Well, injection type, my lord. That training is necessary.
Yes.
My lord, intrauterine contraceptive device.
All right.
Now your lordship will turn to page 36. Page 36, my lord.
Yes.
My lord, what I am trying to say, my lord, every time Ayush is mentioned, last line, my lord. Health and teams, the block level consisting of Ayush doctors. So, my lord, central government every time feel in all programs, Ayush doctor. But here what happened, my lord, the homeopathy doctors are excluded every time. Now, Annexure 8, my lord. Annexure 8, I have read, my lord.
Yes.
Annexure 9. Office memorandum. It is from New Delhi, my lord. Engagement of Ayush doctors Ayurveda and homeopathy in the public health system to provide SBA service. SBA full form. On the strategic national health mission and exam, it is mainstream Ayush doctors into existing healthcare services delivery system. As you are aware that there is a vast workforce of Ayush doctors working in rural and semi-urban sector. Some of them are conducting deliveries after undergoing SBA training, are providing
No, skill work attendance.
Swachh Bharat Abhiyan, that is SBA. Based on recommendations from ICMR study on competencies of Ayush doctors after SBA training, it has been decided by the MOHFW that Ayush doctor, Ayurveda and homeopathy posted at government health facilities may be permitted to conduct deliveries and provide basic treatment for complications before referral. Only those doctors who are posted at delivery points or sub-centers where ANC and PNC are conducted may be trained as SBS training. They may be permitted for prescribing allopathic drugs for conducting normal deliveries, including initial and basic management of complications before referral. Can prescribe all those drugs permitted by ANMS and SNS after SBA training. States need to ensure good quality training and follow-up along with monitoring and supportive supervision during the training and post-training. Department of Ayush is requested to take simultaneous step for strengthening Ayush pre-service curriculum for including SBA competence, particularly for skill binding. So all programs include Ayush, homeopathy and Ayurveda, and two other, Unani and this naturopathy. So every time it is, now your lordship, annexer annexer 9, my lord, 9. Now annexer 10, my lord. Annexer 10. What happened, my lord? Government of Tripura, annexer 10. Annexer 10, page 40. Government of Tripura, my lord, advertised for some contractual appointment in NHM. Here, my lord, your lordship at page 41, medical officer Ayush. They use the word medical officer Ayush, not this Ayurveda or homeopathy. There is no difference. All Ayush will be taken into consideration. That is the government of Tripura policy, my lord. Now your lordship would be pleased to see in Meghalaya same thing has happened. That Ayurvedic doctor, homeopathy taken together. Now next your lordship will see page 44, West Bengal. West Bengal is doing the same thing. That essential qualification candidate should have BHMS, BAMS, BUMS degree from institution of Bachelor of Hemio and Medicine and Surgery. Both are taken together. So my humble submission before your lordship, all this thing, all money comes from central government, and central government giving same emphasis on the Ayurvedic doctor and homeopathic doctor. But the impugn advertisement, what is done, my lord, that only Ayurvedic doctor are advertised. And this is the regular feature in Assam. Whether in Meghalaya, in Tripura, in West Bengal, my lord, in Manipur, they taking together this homeopathy and Ayurvedic doctors. Now my humble submission before your lordship, that what is my grievance, my lord, I have stated, starting from para 18. Yes. Para 16, my lord, page 15. Yes. My lord, that the respondent number 6 to 42 were selected for engagement on contractual as medical officer Ayur, Assam under administrative control of district health society of respective district, by depriving the writ petitioner in a very illegal, arbitrary and unfair manner. That the selection and appointments of respondent number 6 to 42 have discriminated the petitioners and deprived them from getting equal opportunity in public employment. That the selection and appointment of respondent number 6 to 42 have affected the life and livelihood of the petitioner. That the selection of appointment respondent 6 have violated the principle of national justice. That the petitioner submits that the Ministry of Health and Family Welfare, Government of Assam, vide Annexure 6, 7, 8, 9, documents treated the homeopathy doctor and Ayurvedic doctor at par. But the impugn advertisement failed to give equal treatment to the petitioners along with Ayurvedic doctor. As such, the impugn advertisement is discriminatory and has violated Article 14, 19, 21 of Constitution. That the petitioner submits that the aforesaid documents under Annexure 6, 7, 8, 9 specifically gave emphasis for engagement of Ayurvedic and homeopathy doctors in respect of child and women health care. But in spite of large numbers of qualified homeo doctors, the respondents failed to engage on the one hand, and on the other hand, respondents by impugn advertisement given preference to Ayurvedic doctors, only depriving the petitioner, though there are 976 unemployed homeopathy doctor, and on the other hand, there is only 110 unemployed Ayurvedic doctors. The number of unemployed homeopathic doctors is about 9 times higher than the Ayurvedic doctors. The impugn advertisement totally failed to consider the said unemployed position of the homeopathic doctors in the state. That the petitioner submits that the impugn advertisement failed to consider the fact that the government of India in principle has given equal status to the homeopathic and Ayurvedic doctors. The impugn advertisement completely diluted the aforesaid approach of the central government. That the petitioner submits that the impugn advertisement contradicts with the Annexure 10, 11 and 12 documents without any cogent reason. The Annexure 10, 11, 12 documents are following the planning of the central government in respect of engagement of homeopathy and Ayurvedic doctors. But the impugn advertisement deviated from the same. As such, the impugn advertisement is discretionary to give the equal treatment to petitioner with Ayurvedic doctors. That the petitioner submits that the Ayurvedic and homeopathy doctors are categorized as Ayush. There should be one U, my lord. Ayush, there is no reason to single out Ayurvedic doctors from Ayush, depriving the homeopathy doctors. So, my lord, my humble submission before your lordship is this. So, your lordship pointed out that how this appointment will be cancelled. If, my lord, some appointment is made depriving somebody equally in equal position, that can be cancelled, my lord. That can be cancelled, and we made them party, my lord. We made them party, they did not appear before your lordship. So, my lord, your lordship pointed out to me that your writ petition will be dismissed, and you can withdraw and file a fresh petition. My lord, what I will state in my fresh writ petition, my lord, same thing I have stated here. So, your lordship, if there is some problem, my lord, some problem that Mr. Sheikh, your lordship may point it out that relief cannot be granted to me. In that case also, your lordship can mold the prayer. Your lordship can
What is the relief you are seeking then? Tell me.
My lord.
What is the relief you are seeking?
My relief is this, my lord, against that advertisement, my applications may be
Today,
accepted.
how can it be done? The advertisement is issued in 2019.
No, my lord,
Process is
here your
completed.
lordship,
Hmm.
if illegality has been done, supposing in 2019 illegality has been done.
So you submit a representation that homeopathic doctors should also be appointed, and we'll ask the NHM to consider your and pass an order. That
No,
we
my
can
lord,
do.
in that case, my lord, what my grievance before your lordship,
Hmm.
I have highlighted before your
Your
lordship.
grievance needs
My lord,
needs consideration.
my lord,
That there is no
your
doubt.
lordship. What is my grievances?
Hmm.
I have highlighted before your lordship on record, supporting by documents. If your lordship highlighting my grievances, recording my grievances that these are my grievances,
Hmm.
I will file detailed representation before the authority, my lord. And your lordship, I will pray before your lordship only what is my grievances.
Correct, correct.
What is my grievances in the writ petition that may be placed in your lordship's order. And I will file detail representation before the authority, and authority will consider my representation within a time frame. And what they have decided on my representation, a copy of that speaking order may be supplied to the writ petition.
That can be done.
My lord.
That can be done.
Because my lord,
That's right. That's right. You may have a general
actually, my lord,
grievance.
online. Actually, how we are deprived, we do not know when advertisement will be there.
Correct.
Supposing, my lord, this is not the one case. Every time they are doing this. Advertisement comes, we go for apply. No, it is for Ayurvedic doctor. We rush to the High Court. High Court said that, no, it is for Ayurvedic. How your application will be accepted? Our
Correct,
application is
correct.
not accepted.
You have said that already.
Every time.
Yes,
every time
what is
we
your
see the thing.
stand? Why are you not taking homeopathy doctors?
We have filed our affidavit, my lord, in opposition.
Which para?
8, my lord,
Hmm.
paragraph 8. That as regards to the statements made in paragraph 7 of the writ petition, the deponent begs to state that the advertisement dated 11/1/2019 was published to fill up the vacancies of MO only against the approval in ROP, not for MO Homeo. As per the Government of India approval in ROP, in the advertisement issued, the requisite qualification is BAMS degree from a recognized Ayurvedic college and
No,
registered.
that is all right. That is why you have issued this, but
Yes, my lord.
why aren't you considering to give them also an
Yes, my lord.
opportunity?
Next para, my lord.
Hmm.
The deponent begs to state that it is a matter of record as per the different direction from the Government of India. The Ayush practitioners, including MO Ayur and MO Homeo, are being utilized in various activities relating to RMNCH+A program, RBSK mobile health teams, and the health institution where MBBS doctors are not available. However, this does not create any entitlement of the petitioners for consideration against the advertised post for MOIU, my lord. And the next one also, the deponent begs to state that it is a matter of record permitting the Ayush provides with the exception of yoga and naturopathy provides to provide IUCD insertions was after necessary training only, which did not happen in case of the petitioners. Even then, this would not entitle the petitioners for consideration against the advertisement, my lord. As per the Government of India's guideline.
Right,
my
let
lord.
them file a representation.
Yes,
You
my lord.
consider.
They are working, my lord, at present. In RBSK, my lord, they are 183 are homeopathic doctors, and in others also in 43 numbers. They
So are you
working.
not appointing any homeopathic doctor?
They are not now, my lord, appointing, but they are working in RBSK, my lord.
All right, I heard Mr. M.S. Sheikhlani, counsel preparing for the writ petition.
1 minute. I have filed a reply, my lord, to their affidavit in opposition. The reply I have filed, my lord, on 21, 2021. 21, 2021, your lordship would be pleased to see para 3 and para 4 of my reply. My lord, I am reading para 4, my lord, only. That as regards the statement made in affidavit in opposition under para 7, the answering deponent begs to state that annexure 4 document. What I have stated before your lordship regarding this vacancy position document of the writ petition, it is issued by the director of Ayush Assam. Impugned annexure number 5 document, the writ petition was issued to the executive director, National Health Mission Assam. Director Health Mission Assam.
Mr. Sheikh, the reason I was stopping you is that now I cannot give you that liberty. Because whom they will recruit, whom they will not, is a policy decision. The court cannot.
That policy decision, all right, my lord. What my annexure 4, my lord, that is policy decision. But policy decision cannot be that somebody will be prepared, somebody will not be prepared. Because, my lord, annexure 4 document clearly said the vacancy position, the requirement of.
That is what I am asking. If you want a judgment on merit,
My lord,
then you argue, I'll consider everything.
my lord.
If it is only that your grievance should be looked into by the
My
authority,
lord, that I have already admitted.
then I'm not going to go into all these things.
My lord.
I cannot record everything and then say that let the authorities look into it.
Not everything, my lord. My grievance, my lord. What is my grievance?
Oh, I have noted it. Your grievances you have been ignored.
My lord.
Then we'll ask them to look into your grievance, that's all.
My lord.
Then what is the point in going so deep into the matter?
My lord.
You want to go, I have no problem. Then I'll give a judgment on merit.
No, my lord. Your lordship will sum up definitely. My lord, what is our duty, my lord, before your lordship? To highlight the grievances. Ultimately, judgment will be passed by your lordship. Taking.
I am aware of that.
That's my.
I am aware that the
that is why,
judgment
my
will be
lord,
passed by the court
that-
and not
that is-
somebody else.
That is why, my lord, we are taking the valuable time of the honorable court.
Yeah, but
What is our grievance, my lord? We placed and your lordship will.
you want to place it before whom? You want to place your grievance before whom?
Before the director. Director Health Mission.
So as and when there is a requirement to consider it. Beyond that, nothing can be done in this case. Had Mr. M. Sheikh when it comes.
My lord, when requirement, if your lordship pointed out that when requirement will not arise in any time. But thing is this, my lord, your lordship will take into consideration when Ayurvedic and homeopathic doctors are in same footing as per central government notification. Times and again, you consider Ayush doctor. You appoint Ayush doctor. If that is the position of the central government, why state government, my lord, who is running the National Health Mission under the fund of the central government, my lord, recruiting only the Ayush or only the Ayurvedic doctors, my lord. That is the thing. When requirement required, always they will say that our requirement is Ayurvedic. But central government is saying that Ayurvedic and homeopathic doctors are similar in position. And as per Annexure 4, my lord, they have shown the requirement, they have shown the vacancy position, my lord. My lord.
Had so and so order reserved. Yes,
May it please, Your Lordship.
yes, please.
We are the employees. We are working in the various heads of the department, Your Lordship. Now, in this case, I am claiming a pay parity with my counterparts who are working in the secretariat, Your Lordship. However, in this case, our cases were never presented before the.
The petitioners are employees of which organization?
Your Lordship, we are working in the various heads of the department as junior assistant, as senior assistant, superintendent, registrar, and various posts. So our counterparts are there at the secretariat also. and they are drawing a higher pay scale than us. So this matter has been ventilated since long, Your Lordship. There was a meeting with the Honorable Chief Minister in 1998, wherein it was stated that to look into the grievances. Thereafter, we have represented before the Finance Department. And time and again, this matter was also placed before the Anomaly Committee, but the Anomaly Committee has said that this is not within our jurisdictions. But yes, of course, the matter was never placed before the Pay Commission. The Pay Commission has considered the pay of our counterparts who are working in the district. And they have been given a similar pay scale at par with us. But our pay scale, which we have been demanding, which has to be given at par with the secretariat, our counterparts, was never considered, in fact, Your Lordship.
Yes, you have filed your affidavit. What is your stand?
Six submission will be there. One pay commission report will be there. And on the basis of pay commission's report, we grant them salary and gratuity, whatever option. Until and unless that pay commission's recommendation is set aside by this honorable court or by the government lordship, we cannot give them any relief as claimed in this writ petition. That is one lordship. And the pay commission's report is not under silence lordship in this petition.
What is the date of pay commission's report?
Lordship, here they are concerned with the pay commission of 2008. That is 6 pay commission.
2008.
8. So in the meantime, 7 pay commission also there. And
Seventh
now-
pay commission also did not consider their case.
Nothing, Lordship. They also
Seventh
have,
pay commission did not consider your case.
It was not placed, in fact, for them, Your Lordship.
What is the date of seventh pay commission?
7 pay commission.
2016. 2016.
16. It was published in 2016. And
So, Mr. Sinha, the court can only direct that the matter be placed before the pay commission. So it can be only done in the 8th pay commission, not before that.
That much will suffice my case.
Let the issue be placed,
yes,
matter,
Lord.
their
In the
demands.
meantime, Lordship, whatever I have found in the repetition, once they have already approached the 6 pay commission, Lordship, there it was placed before the anomaly committee also. Anomaly committee declined to grant them any relief as it was not recommended by the pay commission itself, Lordship. So in the next pay commission, Lordship, that is 8th pay commission, let them place their case before the pay commission, Lordship. Here
They will place or who, the government will have to
Government
place.
will place it, Your
no,
Lordship.
even an individual can approach the pay commission, Lordship.
Let the government place it, Your Lordship.
Let the government pay and will give them liberty also to place their grievance.
I'll just point out one thing to that, what my respected senior has said.
Hmm.
The anomaly committee said that the committee found the demands are not within the mandate of the committee. It means the anomaly committee could not have decided on that matter. And therefore, time and again, we have been pressing them that you please look into the grievance and do something. That is the finance department. But they have on no occasion placed it before the pay commission. Because once they place the matter before the pay commissions, they have to also place before the pay commission the entire things. Now, in this affidavit, they have categorically stated that the nature and
That's correct, but at the moment, the court can only
yes,
direct
that's what
that.
I'm saying, Your Lordship. But let them place it, Your Lordship, with all the datas and everything.
All right, then we'll pass that order.
And the matter,
My submission will be, let them produce a
No,
representation.
you also place it, they will grant them liberty to
On
also
the
place.
basis of their representation, we will place this before the pay commission.
Then you
Otherwise,
place-
as we are not agreeable, Lordship, there is no question of
All right,
ourselves
so
placing the issue.
you make a representation before
Yes.
the,
That will be easier.
that will be made before whom?
before
Your
the
lordship,
finance
we have
clear
already
report.
made it. If your lordship kindly takes up.
Oh,
my-
Mr. Sinha, don't create a problem, then we'll hear it after the pay commission comes. Why don't you make a fresh representation?
Okay, your lordship.
You've already made it. What is the point in digging unnecessary? Let it be placed before the chief secretary.
It is possible, Lordship.
You submit a representation with a prayer to place your grievance before the upcoming eighth pay commission. If such a representation is submitted, necessary steps be taken to have the have the representation considered by the eighth pay commission, and decision, if any, in that matter be implemented as per law. That's the direction we can give.
There are only one petitioner. Other petitioner name is related, right? What petitioner?
No, there are not
There are other
only,
petitioners.
there are 8 petitioners.
But the others are deleted.
Other
The
petitioners,
petitioners' names were deleted by the court saying that only one petitioners will ventilate the grievance, your lordship.
Hmm.
But this was.
why it was deleted by the court? Which order?
Petitioner number 1 to continue.
So one is continued. It was passed on 11/9/2023, your lordship. But the grievances are same, your lordship, in that case.
No, his name was deleted because he is the only one who has sworn the affidavit.
Yes, your lordship. Only one petitioner owned the affidavit.
But he says I am authorized and competent.
Yes, your lordship. But none of the other petitioners said that they have not authorized me. It was the court on its own have said it that only this petitioner. But however, your lordship, the association has been ventilating the grievances all throughout.
Right, you take the heard Mr. R. Sinha, learned counsel appearing for the writ petitioner. Also had Mr. P. Nayak, learned additional advocate general Assam appearing for, the notification has come out?
Yes.
Additional AG,
Yes.
yes. Appearing for the respondent numbers.
Lordship, 2 to 7, 6, Lordship.
2 to 6.
One also.
2, 3.
Then you will appear for all the respondents.
Yes, I can.
Appearing for all the respondents. Along with Mr. T.C. Chutial and additional senior government advocate Assam. Stop. The writ petitioner hearing is a member of the All Assam Heads of Department Ministerial Officers Association. Presently, he is serving as petitioner number 1 is serving as. Presently, the petitioner number 1 is serving as. So and so, it appears that by order dated 11/9/2023, the names of the petitioner numbers 2 to 8 had been deleted due to the reasons made therein, due to the reasons mentioned therein, be that as it may, considering the nature of grievance expressed in this writ petition, this court is of the view that a limited order, this court is of the view that limited relief in the format narrated herein below can be granted to the petitioner. Full stop. The basic grievance of the petitioners is that there was no pay parity with their counterparts serving in the various departments in the Assam Secretariat. Full stop. The petitioners' counsel submits that the request for pay parity was made before the 6th Pay Commission, bracket 2008, but bracket close, the same was denied. Thereafter, the 7th Pay Commission, bracket 2016, had also not considered their grievance for pay parity. First up, hence this writ petition. First up, Mr. Nayak has pointed out that since the recommendation of the sixth and seventh CPC is not CPC, seventh pay commission are not under challenge, and considering the fact that the state has to abide by the recommendation of the pay commission, no relief as prayed for in this writ petition can be granted. However, if the petitioner or the association submits a representation before the respondents, the same will be placed before the eighth pay commission if a direction to that effect is issued by this court. So responding to the above, Mr. Sinha has agreed to submit. Mr. Sinha has also agreed to the proposition made by the Planet Additional AG Assam. In view of the above, without commenting on the merit of the claims and counterclaims the parties in this writ petition, this proceeding is being closed by granting liberty to the writ petitioner number 1 or the all Assam heads of department, ministerial officers association, as the case may be, to ventilate their grievance in the form of a representation to be submitted before the respondent number 1 within 8 weeks from today. If such a representation is submitted along with a certified copy of this order, the same be placed before the upcoming 8th pay commission for consideration of the same in accordance with law. With the above observation, writ petition stands as order.
Your Lordship, there is a slight correction. What my respected senior has said that the sixth pay commission and the seventh pay commission has rejected our play. It's not the case. It was not placed at all. That's one basic case.
It was placed before the anomaly committee, Lordship. It's
It was
not
only
recorded.
placed before
On
the
record.
anomaly committee. Anomaly committee.
Mr. Nayak submits that the grievance of the petitioner was placed before the anomaly committee, but since the matter was not considered by the sixth and the seventh pay commission, no action could be taken in the matter by the state. Now this is correct. Yes.
Deeply obliged, Your Lordship.
Should decline the sixth pay commission, decline that part is not. The last matter.
The matter relates to appointment and equivalence of qualification. This petitioner, my lord, he is a postgraduate diploma holder in global business operation, my lord. He passed from the Sri Ram College of Commerce, which is a leading institute as far as commerce and management is concerned, my lord. In the year 2017, my lord, recruitment process was commenced by the IOCL. The initial qualifying criteria was that you have to pass UGC NET. Only UGC NET qualified candidates can come and apply. And thereafter screenings took place, my lord. The advertisement is at page 12 and Excel 1.
Page 12.
Page 12 and Excel 1. Petitioner was UGC qualified, so initially he came into the screening process. But apart from UGC, my lord, lordship would look at the clause 1, educational qualification. Clause 1.1.1 is the basic educational qualification. It says 2 years full-time regular course leading to postgraduate diploma PGDM. Public master's degree in business administration or equivalent with specialization in marketing management or an equivalent qualification from a recognized Indian university or institute. How I read this, my lord, is that the first part of the advertisement, it says
Come to
diploma.
it. So this advertisement was issued in the month of
November 2017.
November 2017. What has happened? The recruitment process is complete.
Recruitment process was, my lord, completed. I was, my lord, turned down saying that my qualification is not equivalent. I obtained an interim order that one post would be kept vacant. Thereafter, my lord, because of COVID, my lord, hearing got somehow deferred and from one
And
year to
one
the
post is
other.
still vacant.
I believe so, my lord. The interim order is still there. Interim order is still there.
So according to you, the post you are holding is equivalent to
Well,
postgraduate diploma or master's degree in business administration. Which one?
Well,
Which one? It is
well,
equivalent to which one?
What I say, my lord, is that it recognizes, my lord, diplomas also and also a MBA. My lord, MBA and diplomas are two different things again. But then both of these are, what I see from the advertisement, are recognized. I am not having an MBA, my lord. I am having a diploma. So my equivalence, my lord, has to be seen from the perspective of a diploma. The difficulty, my lord, that arose in my case that when I qualified, subsequently the IOCL said that your result is vital because we are clarifying with the university as to whether your degrees are equivalent or not. Now that letter, my lord, would see.
But is the university, who will, the court cannot decide whether it is equivalent. Who will decide that?
My lord, I'm pointing on how the problem arose. My lord.
Who will decide whether it is equivalent or not? You can't decide.
I cannot
The
decide.
court
The
cannot
court cannot
decide.
decide.
Who can decide?
The respondents have to take a call again, my lord.
They have
Because-
decided that
No,
it is.
they have taken a wrong call, my lord. They have to
Who will
reconsider.
decide that they are wrong?
My lord, how they are wrong, my lord? This the court can decide, my lord. Why it was wrong, my lord? When they made a query to the university, my lord, if your lordship comes to case 28, my lord.
28. Yes.
What they sought, the instruction they sought from the university was that whether my postgraduate diploma is equivalent to a MBA. They did not mention that there is a qualification also of a diploma, my lord. The university sent it to the concerned college, my lord, at page 30. They sent it to the SRCC college.
So your qualification is a graduate diploma or a postgraduate
Postgraduate
diploma?
diploma.
Where is the certificate?
Well, that I have not put in here, my lord. But then obviously, my lord, that is not in dispute. That is not in dispute. Only the question of equivalence is there, my lord.
That
The
cannot be
query,
decided.
the query that was, my lord, put, my lord, was that whether my postgraduate
What is the
diploma,
order? What is the order you are seeking from the court today?
my lord, what
That
I
it
would
is
say,
equivalent.
they have to review it with the university because the query they had put to the university was that they had asked whether MBA is equivalent to diploma. Answer is obvious, no, my lord. I also know. But then whether my diploma is equivalent to the postgraduate diploma is the query that ought to have been sought, my lord.
No, but you should have made the university a party. We would have got the query. You have not made it. The university which has given you the diploma.
My lord.
We could have asked them. You have not included their university as a party.
My lord,
They have
that
the
is-
specialized people to give the answer. no?
I understand. The advertisement said that, my lord, only in cases where the ascertainment of equivalence is to be done by them.
So you have understood the point.
I have
Now you argue. Then I'll pass you on.
Then the other point is that they say that if however you look for equivalence of degrees, then you have to write to the and get a certificate from the Association of Indian Universities. The AIU guidelines, my lord, again are different. AIU only gives equivalence of degrees which are obtained from outside India, my lord, whether they are at par or which are standalone institutions, whether they are equivalent to, my lord, university degrees. This is what the AIU certifies. So AIU, I could not have brought in, my lord. The only thing is that the query that was put to the university from their side
So what
was
is
a
the
wrong.
material you have placed on record to show that it is equivalent?
My lord, SRCC themselves and my lord subsequently pointed out
SRCC means?
the Sridham College of Commerce because
Where is
Delhi,
it?
the
Which-
Delhi University had, my lord, had put the query to the concerned college. The concerned college, my lord, at page 31, annexure 9, has given this certificate. This is to certify that Gaurav Datta, son of so-and-so, roll number so-and-so, batch of 1315, has successfully passed 2 years full-time postgraduate program. So this PG program, my lord, though I have not given the mark sheet, my lord, this has come in here. titled PG Diploma in Global Business Operations offered by Sriram College of Commerce, a constituent college of University of Delhi. The University of Delhi awards the unique PG Diploma in Global Business Operations on successful completion of the course. PG Diploma is a global business operations program and it's spread over 4 semesters of coursework besides summer internship. The core subjects are the marketing core subjects are indicated because the qualification again says that I should have, my lord, 4 marketing subjects as far as equivalence is concerned. So this aspect,
Where is the opinion of an expert saying that these are equivalent?
the college has to be considered the expert, my lord. The university and the college is to be considered the expert, my lord.
See, there is a order of 6th of February 2024,
My lord.
where it's the learned judges recorded that you have not even placed that principal Ram Sriram of Ram College, Sriram College on record.
No, my lord, the question was that on that day, there was some confusion, my lord. They said that we have some additional instruction. That instruction I was not aware of. But then subsequently, when I got a copy of the said letter, I could find that, my lord, this is same as Annexer 8 in my petition. This is what the SRCC college had written. So my copy was probably not legible and therefore, my lord, there was some confusion.
Your client is still unemployed.
My lord, he is doing some private job.
I'm sorry.
He's doing some private job, my lord.
That's right, but Mr. Pathak, what is the material for the court to take a decision this way or that way?
I understand, my lord. Equivalence is a very complicated subject, my lord. But then had the query from the IOCL at that point of time to the university was that
could be
whether
one-
diploma, my diploma is equivalent to PGDA,
That could be one facet.
my lord.
You have to, if you are coming to court, you have to come up with some material facts in particular.
My lord.
You have not produced the certificate from
No,
which the court could have made an assessment, what
Yes.
is really your degree diploma. So you have,
Annexer 9, my lord, is the,
Connection 9 is not your certificate.
Where
Where is your, how does the court know that you have passed?
this Sriram College is clarified, my lord. And that was basically,
that is not-
my documents were scrutinized. I had crossed the threshold. Only at the time of appointment, they said that whether your degree, PG degree is equivalent MBA or not is the query that we are putting. My point is that, my lord, you should have put a query that whether my postgraduate diploma is equivalent to
No, you
PGDM.
can't come to read court saying what they should have done and they should not have done. You have to make out your
My lord.
case.
No, if they do wrong, what I am pointing out is that
You
they
may
have
do
done
wrong, but if they do wrong, then only the court should look into, not yours.
No, I have.
Where is your certificate? How does the court write in the judgment that he has obtained a PG diploma in global whatever it is? Some whomever may concern and he is not even a party. This is complete lack of transparency in your case, Mr. Pathak.
Graduation certificate, the PGDA certificate, I can always produce, my lord. I can always produce.
This time I think it is too late. That should have been the basis of your case. That this is the certificate.
At that
This
point
is
of
the-
time, they did not confess that aspect. They said that it's all right, you have a degree from the Commerce College, Sriram College Commerce. But the only thing is that whether it is equivalent or not is what we are ascertaining from the university. The university wrote to the college. The college wrote back saying that, yes, you cannot be equated, your diploma course cannot be equivalent to a MBA degree, my lord. That
Where
of
is-
course I am also, my lord, clear.
Whereas those communications,
My lord, what you could
page
look at.
28 is,
Page 28 is the letter from the IOCL to the registrar at Delhi University. Before that, my lord, at page 24, they put my results at hold by saying that whether my postgraduate diploma in global business operation is a program equivalent to MBA marketing or not. And the clarification that comes, my lord, at page 30. It is not equivalent to MBA. But it is a
clarification at page.
Page 30, my lord. 30A is the original copy. 30 is the type copy, my lord. Again, my lord, submitting that I have never said that I am equivalent to MBA. Because I have done a diploma course, but in your advertisement said that you can have a diploma stroke MBA. So the query to the university should have been, my lord, whether my diploma is equivalent to PGDM, postgraduate diploma in marketing. That ought to have been the query. Then the question of equivalence could have been judged, my lord. Now I've been put in a different yardstick altogether. MBA, I cannot be equivalent because that's a master's degree, my lord. It's not a
That's
diploma
correct,
degree.
but that's what I'm saying. You have not impleted the university.
The university has done nothing wrong, my lord, here. University has only replied to the question that was put to them.
Yes. Mr.
Had the
Chaudhary.
right question be put to the university, my lord, probably we would have got a right answer.
My lord, if we come to the advertisement, my lord, the educational qualification, if we read it once again, my lord, at page 12. 2-year full-time regular course leading to, I'll read it as either PG diploma or master's degree. Now, my lord, in fact, your lordship's query that certificate, whether it was a full-time course, that is one aspect, my lord. And secondly, my lord, equivalence with either, my lord, diploma or MBA. So, my lord, he has not put anything on record to show that, my lord, it is a full-time course. And that, my lord, it is equivalent with specialization in marketing management. And the, my lord, the better copy of the, my lord, communication from the, my lord, Sriram College of Commerce, if I am allowed to place, my lord, because that was, of course, that it has been typed properly. And my lord, the university is the authority who will decide, my lord, whether it is equivalent or not. My lord, we may have asked the question which may not be, my lord, the perfect question that ought to have been asked. But then, my lord, the reply would have given the clear picture. Had, my lord, the university be there. In fact, my lord, the All India Council of Technical Education is also a necessary party, my lord. In the last representation, he has made.
That's what I'm asking. If the court is to resolve this issue, then anyway.
It will also be a necessary party.
All right. Yes, Mr. Patel.
As far as the full-time aspect is concerned, my lord, page 31, my lord, the SRCC says that it is a full-time recognized course of the Delhi University, my lord. I'm only stuck on this aspect, my lord. My equivalence is with a diploma, my lord. It's never with an MBA. They are asking equivalence with the MBA. The university will obviously say that it's not equivalent to MBA, but then they have clarified that I have specialized subjects in marketing. The question ought to have been, my lord, that whether my diploma is equivalent to a PGDM.
No, but can the court ask you why haven't you annexed your certificate? This is the fundamental document. Today, will not accept that you are even a PG diploma in global this thing. That also the court cannot record in a judgment. Tomorrow, if it is found not to be correct, then it will be embarrassing for the court. Was it not required for your client to place it on record?
Well, at that point,
Whatever you are
probably
claiming,
at that point of time,
you have to come up clean with your case that I am a postgraduate diploma in global business operation and this is my certificate. You have not placed it. So today we don't know whether you are even the post mayor may not be equivalent, but you may not be holding this degree or diploma. Where is the basis for the court to presume it? Certificates could be given by anybody anywhere. That person is not a party.
In fact, my document verification at that point of time was over. So documents they had found all right. Therefore, I sat for the group discussion and interview, and I was ultimately selected also. But then I could not be appointed because they said that we are putting a query as to the equivalence. So I believe, my lord, my qualification as such was not in question, that I was holding a PG diploma. So because that is the precise query that they had put, that whether this is equivalent or not to the MBA is the query that they had specifically put. So probably at that point of time, it did not strike my mind to put that, my lord. Because that was never in dispute at that point of time. Only the equivalence aspect is in dispute, my lord, which probably ought
done here,
to be.
Mr. Chaudhary.
Well, he'll It will be required, my lord, if we continue with this proceeding, my lord, the UGC and the ICT has to be, my lord, parties.
Order result.
AIU, they say that we can ask for the AIU, but then AIU guidelines I have next, my lord. AIU
this one's
cannot be
already-
a party because they cannot like judge the equivalence aspect, my lord. As far as
Uh,
degrees by Indian
appearance-
university is concerned.
appearance.
My only prayer would be they should put a reconsideration, my lord, on the aspect that my degree is a diploma degree, and whether that diploma is equivalent is what you have to judge. If not the university, you can.
No, the court is not accepting that you are a PG diploma holder because there is no proof to that.
My lord, annexure 9 page 31, my lord, a
Where
certificate.
is the authentic certificate by the institution?
That I can get in half an hour, my lord.
But it's too late for this time.
My lord,
After
he's
6
otherwise a
years-
brilliant boy, my lord. Otherwise, he must have got some better opportunities in the meantime. My lord. So many years have passed by, and one post is vacant. We have kept it
After
there.
6 years, what is the order? The court cannot say it is equivalent.
I understand, I
Then-
understand. The court cannot say
At
equivalent.
least if that case was projected and we had the opportunity to verify and see whether the answer is acceptable or not,
My lord.
that is fine. You are saying that, okay, I have not given any document, but they have not asked the right question. If the right question was asked, then the answer would have been different. That's your case.
Would have
Show
been
me
right.
something to come to that conclusion. Show the court something to come to that conclusion that yes, see, these documents show that this course is equivalent to this. But today, I'm not getting the relief because they did not. Where is your? Why should the court ask them to ask another question? You have to produce some prima facie material.
My lord.
Where is that?
Because in reply to the query to the
No,
university,
no
the
question.
college had replied, my lord, clarifying.
You
this
show
aspect.
the court that this is the answer, but because they have not put the right query, the wrong answer has come. That you have to show.
My lord, that I have shown, my lord, that I have shown because that I have
Shown
shown the
where?
commu-
Where? From
I have
where?
shown the communication where the query is made. And I have shown the answer also, my lord, by which the university has replied through the college.
Hmm. So are you willing to ask the right question again?
My lord, the necessary parties are not before your worship, my lord.
Because university would not have anything to say. I cannot have a cause of action against the university, my lord, for anything in this matter, as far as equivalence
All
is
right.
concerned,
So that's all. We'll go through the record and see.
my lord.
Right? Appearance. That's all.
All this. Keep your place.